Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Did Speaker of the House Nancy Pelosi violate federal law when she tore up President Trump's State of the Union speech? If so, she could be prosecuted and incarcerated if convicted and removed from office. The relevant federal statute states this. Whoever willfully and unlawfully mutilates, obliterates, or destroys any record, book, paper, document, or other thing filed or deposited in any public office or with any public officer of the United States shall be fined under this title or imprisoned not more than 3 years or both. And that's Title 18 of the United States Code, Section 2071A. There's also a subsection B, and the two are to be read together. B states, whoever having the custody of any such record, document, paper, or other thing, willfully and unlawfully mutilates, obliterates, or destroys the same, shall be fined under this title or imprisoned not more than 3 years or both, and shall forfeit his office and be disqualified from holding any office under the United States. As used in this subsection, the term office does not include the office held by any person as a retired officer of the United States Armed Forces. And that's subsection B of 2071 of the U.S. Code, which is found in Title 18, the Crimes Code. So let's break down the two statutory sections and do some legal analysis here. Well, we will analyze subsection A first. So the first dependent clause in A reads, whoever willfully and unlawfully mutilates, obliterates, or destroys. Well, I think Pelosi certainly mutilated, obliterated, and destroyed the written State of the Union address that the president delivered to her. No question about that. Did she do it willfully and unlawfully? That's the second part of the analysis, which we're going to pause on for now. We'll get back to later. In the meantime, we'll analyze the remainder of the dependent clause in subsection A, which reads, any record, paper, document, or other thing. Well, the president handed Nancy Pelosi a document. It was a copy of his speech. So he certainly handed her a paper, document, or other thing. It was written on paper. So that that element of the offense is satisfied. Was the paper filed or deposited in any public office or public officer of the United States? Well, we know it wasn't filed. The president simply handed it. But it was likely deposited. The term deposited, as used in the Act, means the delivery of a paper to one entitled to have the official custody of the paper, either to be kept or to be redelivered after it has served its purpose. And it's to one having a right to receive it. Well, I think the president did deliver the paper to Nancy Pelosi. And the question then is Pelosi entitled to have official custody of Trump's State of the Union speech? And I'm going to argue the answer is yes. Article 2, Section 3, Clause 1 of the Constitution. And remember, Pelosi is always saying, it's the Constitution. It's all about the Constitution. Well, the Constitution requires the president to periodically, quote, give to the Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. Well, the president gave this information in the form of a piece of paper to the Speaker of the House, who is the presiding officer of the House of Representatives, one of the two chambers of Congress to whom the Constitution requires the president to present this report. So I think that element has been satisfied. Did Speaker Pelosi have custody of this paper? Well, custody means keeping and implies responsibility for care and guarding against harm of a person or thing entrusted to that particular custodian. I think arguably the answer is yes. But here is an important question. Is the Speaker of the House a public office? Or is Nancy Pelosi a public officer of the United States? And I think that's debatable. And I think actually it's likely that she's not a public officer of the United States. The appointment clause of the Constitution, Article 2, Section 2, Clause 2, empowers the President of the United States to appoint, quote, officers of the United States, end quote, which of course excludes Pelosi. Pelosi is not appointed by the President. She's elected to the Congress by the constituents in her district, and then she is elected to the position of Speaker by the congressmen and women in Congress. So I think that element is likely not satisfied. But there's another way the element could be satisfied if the Speaker of the House is a public office. And courts interpreting Title 18, Section 2071 have interpreted the word public office broadly, but there are no cases that I can find applying it to members of Congress or to offices within Congress. And there are no cases that I can find in which members of Congress have been charged under this particular criminal statute. So this one is questionable. What about willfully and unlawfully? The requirement of willfulness under the code and the criminal code and section is satisfied if the accused acted intentionally with knowledge that he was breaching the statute. This is a specific intent crime. The prosecutor, if the Department of Justice wants to prosecute Nancy Pelosi for this alleged crime, they're going to have to get into her mind. This is one of the specific intent crimes. It's rare in the criminal law to have specific intent crimes, but we do have some of them. And this is one of them. The prosecutor and ultimately the jury has to kind of crawl into the mind of Nancy Pelosi to determine if she knew what she was doing was unlawful. Now, in the prosecution of Colonel Oliver North for the Iran-Contra affair, he asked for and received a jury instruction that required the prosecutor to prove beyond a reasonable doubt that he knew what he was doing was unlawful when he destroyed government records associated with Iran-Contra. Here, any prosecutor will likely have a problem. It may be difficult to prove Nancy Pelosi knew that destroying the president's speech was unlawful. Plus, it's debatable whether it is in fact unlawful. Now, moving on to the next point. Some have argued that the paper the president handed to Pelosi was a copy, and as such, it is not covered by the statute. Well, it is likely untrue that copies are not covered by the statute. According to one federal court case, copies of government records function as records for the purposes of this statute. And that's the case, United States versus Lang, that was decided in 2005. Now, in the Lang case, the defendant had taken a copy of a sealed document from the federal district court in which she worked. She was convicted of violating Title 18, Section 2071A, and sentenced to prison. However, there is an older case holding copying of the government record is not covered by this statute. So this issue concerning the copy is debatable. Now, Nancy Pelosi, in her public statement, claims she destroyed the document because it did not contain the truth. She stated, quote, "I tore it up. I was trying to find one page with truth on it. I couldn't," end quote. Pelosi is thus asserting the defense known in the criminal law as justification. Actions taken in self-defense, in defense of property, in defense of other persons, or actions taken to avert a public disaster or a crime may be held non-criminal conduct under the justification doctrine, but obviously none of those conditions exist in the Pelosi case. Now, she'll argue she tore it up to prevent a disaster of having the president's speech, copied or on record, but that would be a laughable defense. So there is no criminal justification. There's no defense of justification based upon the statements of Nancy Pelosi and the facts of the case. Now, some have argued that the original speech was submitted to the National Archives, and it is the original speech, that cannot be destroyed. But we've learned that copies can be protected according to one federal court decision. And even more importantly, the Constitution requires the president to present his report to Congress, not the National Archives, which did not exist at the time of the writing of the Constitution. Now, Trump presented his report to Congress when he delivered his speech to Vice President Pence and Nancy Pelosi, the leaders of the Senate and the House, respectively. Now, we can examine the purpose of the statute if we're trying to look for some more context and some greater understanding about when and why this statute is used by prosecutors. But that's always a tricky proposition because the purpose of the statute is often something the courts, instead of those who actually write the statute, decide through various court opinions. Now, there is one case that states the purpose of this Section 2071 is to prevent any conduct which deprives government of the use of its documents, be it by concealment, destruction, or removal. The statute does not embrace any and all instances of removal of government records. It proscribes that removal which deprives the government of the use of its records. So, did Nancy Pelosi, by ripping up the copy of the speech, deprive the House of Representatives of the use of the record of the president's speech? Probably not. So in conclusion, I would say my opinion is it is more unlikely than likely that Speaker Pelosi violated Title 18, Section 2071 for ripping up the copy of the President's State of the Union speech. Plus, in the criminal law, criminal statutes are to be interpreted narrowly and not broadly. And the rule of lenity applies, which favors defendants prosecuted with offenses that are perhaps overly broad or vague and not clear-cut. So I think it's highly unlikely that Nancy Pelosi, well, it's unlikely Nancy Pelosi violated the law, and highly unlikely that she'll be charged with violating this law for the act of ripping up President Trump's State of the Union speech that he delivered to her. Well, that's all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.